Paul Gacheru is criminally responsible under Article 25(3)(a) as a direct co-perpetrator, or alternatively under Article 25(3)(b) for solicitation and or inducement of the crime of corruptly influencing a witness by paying witness P397 1 million Kenyan shillings and by offering to pay the witness 5 million Kenyan shillings in order to influence the witness to withdraw as a prosecution witness, committed from April 2013 to January 2014 and at Eldoret, Kenya. Count 2. Corruptly influencing a witness. Article 71C of the statute, read in conjunction with Articles 25(3)(a) or alternatively 25(3)(b) of the statute. Paul Gacheru is criminally responsible under Article 25(3)(a) as a direct co-perpetrator, or alternatively under Article 25(3)(b) for solicitation and or inducement of the crime of corruptly influencing a witness by offering or paying witness P516 a bribe of at least 500,000 Kenyan shillings in order to influence the witness to withdraw as a prosecution witness, committed in April and May 2013 and at Eldoret, Kenya. Count 3. Corruptly influencing a witness. Article 71C of the statute, read in conjunction with Articles 25(3)(a) or alternatively 25(3)(b) of the statute. Paul Gacheru is criminally responsible under Article 25(3)(a) as a direct co-perpetrator, or alternatively under Article 25(3)(b) for solicitation and or inducement of the crime of corruptly influencing a witness by offering to pay witness P613 a bribe and a job offer inducement in order to influence the witness to withdraw as a prosecution witness, committed from April to September 2013 and inter alia at Eldoret, Kenya. Count 4. Corruptly influencing a witness. Article 71C of the statute, read in conjunction with Articles 25(3)(a) or alternatively 25(3)(b) of the statute. Paul Gacheru is criminally responsible under Article 25(3)(a) as a direct co-perpetrator, or alternatively under Article 25(3)(b) for solicitation and or inducement of the crime of corruptly influencing a witness by offering to pay witness P800 a bribery payment of between 1,500,000 and 2,500,000 Kenyan shillings in order to influence the witness to withdraw as a prosecution witness, committed in or around July 2013 and inter alia in Kenya. Count 5. Corruptly influencing a witness. Article 71C of the statute, read in conjunction with Articles 25(3)(a) or alternatively 25(3)(b) of the statute. Paul Gacheru is criminally responsible under Article 25(3)(a) as a direct co-perpetrator, or alternatively under Article 25(3)(b) for solicitation and or inducement of the crime of corruptly influencing a witness by offering witness P495 a bribery payment of 2.5 million Kenyan shillings and a job offer inducement in exchange for the witness's withdrawal as a prosecution witness, committed in or around September 2013 in Kenya. Count 6, corruptly influencing a witness, Article 71C of the statute, read in conjunction with Articles 25.3a or alternatively 25.3b of the statute. Paul Gacheru is criminally responsible under Article 25.3a as a direct co-perpetrator or alternatively under Article 25.3b for solicitation and or inducement of the crime of corruptly influencing a witness by offering witness P536 a bribery payment of at least 1 million Kenyan shillings or at least 1,400,000 Kenyan shillings in exchange for the witness's withdrawal as a prosecution witnesses committed from May to August 2013. Thank you, Your Honor.
Madame la greffière.
Judge Alapini, thank you very much, courtroom officer. We shall continue as to the verifications. Mr. Gacheru, have you understood the offences with which you are charged? Please stand. Please stand, Mr. Gacheru. There we are. We can't see you correctly now, and I would very much like to have to dispense you from rising to your feet on each occasion, because I do need to be able to see you. So if I can't see you correctly, I would suggest that you remain seated. Do you understand?
Thank you, Judge. I can do either of the two. But since, Judge, you are not seeing me, I can sit.
Oui, asseyez-vous, s'il vous plaît.
Judge Alapini, yes, please be seated, then I can see you properly. Thank you. So I would like to reiterate my question from earlier. Have you understood the offences with which you are charged?
Honorable Lady Judge, I have understood the alleged offences with which I have been charged. I have understood them.
Je vous remercie.
Judge Alapini, thank you. And still in the same vein, I would like to make sure that you have been informed of your rights under the Rome Statute, and in particular Article 67 thereof. Have you been informed of these rights, Mr. Gacheru?
Honorable Lady Judge, on 3rd of November, a representative of the registry informed me of my rights under Article 67, and on that basis I therefore wish to confirm that those rights have been explained to me. Thank you.
C'est moi qui vous remercie.
Judge Alapini, thank you. But we have to go through the usual formalities and remind you of some of these rights. So, in an excess of zeal that will not be harmful. So, in any case, you have rights under Article 67 of the Rome Statute. You have the right to be informed promptly and in detail of the nature, cause, and content of the charges against you in a language which you fully understand and speak. You therefore have the right to the assistance of a competent interpreter free of charge and to such translations as are necessary to meet the requirements of fairness. You have the right to be presumed innocent until your guilt has been established beyond reasonable doubt. The onus is upon the prosecution to prove your potential guilt. You also have the right not to have imposed upon you any reversal of the burden of proof or any onus of rebuttal. Mr. Gacheru, you have the right to adequate time and facilities for the preparation of your defense and to communicate freely and confidentially with the counsel of your choice when you have made one. You have the right to be present at your trial, to conduct the defense in person, as you are doing now, a right you are exerting today, or you have the right to legal assistance of your choosing. You have the right to be tried without undue delay. You have the right to remain silent or not to be compelled to testify or to confess guilt. You have the right to make an unsworn oral or written statement other than any other communication pursuant to the statute. The prosecution shall, as soon as is practicable, disclose to you evidence which tends to show your innocence or evidence that might bring into question the credibility of prosecution evidence. Mr. Gacheru, I am addressing you once again. Do you have any observations to make as to the conditions of your surrender to the ICC and the conditions of your detention at the headquarters of the ICC in The Hague since your arrival? Please do not get to your feet because I still want to be able to see you when you answer. Thank you.
Thank you, Judge. As to the conditions of surrender, I wish to confirm to the court that, Honorable Judge, I surrendered myself to this court, to the Dutch authorities first, on 2nd of November 2020. This surrender was without coercion from anybody. It was voluntary, and I did so at my own expense, Honorable Judge. So it was a voluntary surrender. There was no threat, there was no coercion. On the conditions of detention, Honorable Judge, the conditions, I have been treated quite well. I have no complaint as to the conditions, and the officers in charge of this particular facility and the Dutch authorities were very, very helpful. So I have no complaint whatsoever. Thank you, Judge.
Je vous remercie, Monsieur.
Thank you, Mr. Gacheru, for your reply. and we have noted this. Still on the subject of your rights, I would like to look at the question of a potential request for interim release. So in accordance with Article 60 of the Rome Statute, I must ensure that you have been informed of your right to formulate a request for interim release while attending before the trial. If you were to submit such a request, it would need to be in writing, and the prosecutor would then be invited to comment on this before the chamber makes any decision. That's what I would like to say to you about your rights as a suspect before the International Criminal Court. I would now like to examine the question of the confirmation of charges and whether there will be a hearing to that end. We are now firmly convinced that you have been informed of the offences against administration of which you are charged and the rights granted to you by the statute for your defence. So, with regard to questions related to procedure of the confirmation of charges and any hearing to that end, Rule 121-1 of the Rules of Procedure and Evidence state that at the first appearance, the pretrial chamber shall set the date on which it intends to hold a hearing to confirm the charges. However, here I would like to recall the special procedure which applies to cases relating to offences against the administration of justice as set out in Article 70 of the statute. To that end, Rule 165-3 of the Rules of Procedure and Evidence state that cases relating to Article 70 of the statute and for the purposes of Article 61, the preliminary chamber may make any of the determinations on the basis of written submissions without a hearing unless the interests of justice otherwise require. The chamber considers at present that given the nature and the scope of this case, it is not necessary to hold a confirmation of charges hearing. Nevertheless, I would like to apply the logic contained in Rule 121-1 of the Rules of Procedure and Evidence, which seek to give an indication of a calendar for the proceedings, notably for the benefit of the suspect. This is why, at this stage, I would like to fix a date for the filing by the prosecutor of his document setting out a detailed description of the charges and a list of evidence. Do you wish to speak at this stage? If not, you can have the floor later. So, having taken account, amongst other things, of the need to give the parties the time to prepare themselves, the particular circumstances of the current health crisis, and the nature and scope of this case as described in the arrest warrant, but also the right of the suspect to be judged without undue delay, I fix the date for the filing of the document containing a detailed description of the charges and a list of the evidence on which the Office of the Prosecutor intends to base the case as the 12th of February 2021. The defense, if it so desires, may file in accordance with Rule 121-6 of the Rules of Procedure and Evidence, as well as a list of this evidence no later than the 26th of February 2021. And continuing along this line, the defense can also excuse me, says the judge. The parties can then present their written conclusions by the 15th of March 2021 at the latest, which is 30 days after the filing of the document containing the charges. After that, the prosecutor will have until the 22nd of March 2021 to present a reply to the written submissions of the defense. And finally, as the law decrees, the defense will have until the 29th of March 2021 to reply to the submissions of the prosecutor. The date for the filing of the document containing the charges could be postponed by the Chamber, depending on how the procedure develops, either on its own initiative or at the request of the prosecutor or of the defense. The Chamber will decide on any request submitted in writing and with justification. In order that the procedure goes smoothly, I think it is also important to ask the prosecutor to file observations on the progress of his investigation, as well as on the disclosure of evidence, as well as questions relating to the protection of witnesses. You should file these observations by the 18th of November 2020 at the latest. In order to deal with everything at once, I will also deal with the matter of the second suspect in the arrest warrant, so that we can see together how we can effect a severance of the proceedings One of the suspects is here in front of us today, but Mr. Philippe Kikwet is still at large. Under Article 64(5) of the statute, it is possible to direct that there be joinder or severance as appropriate in respect of cases against more than one accused, which is why I would like to hear from you, from the parties, the prosecutor, but also from Mr. Gacheru. Would like to hear what your observations are relating to a possible severance of the two cases. I suggest that the prosecutor file any observations on this subject by the 20th of November 2020, even though you might like to say something about this shortly. And the defense, if it so desires, can reply by no later than the 26th of November 2020. I hope that was all sufficiently clear. So that's what I want to say on the subject of how the proceedings will take place, point by point. And at this stage, I felt there was not much that needed to be said, but we need to ensure that certain formalities are satisfied and that we have an indication of how this will proceed. However, before closing the hearing, I understand that the representative of the prosecution would like to speak, and we can also thereafter give the floor to Mr. Gacheru.
Thank you very much, Your Honour. Yes, indeed, I thank you for the opportunity to address the court. There are actually several issues I would like to briefly address. Starting off perhaps with a matter which I think, out of an abundance of caution again, I should raise in the presence of the chamber and of the suspect, Mr. Gacheru. And that relates, Your Honour, to a filing that was submitted by the Office of the Public Counsel of Defence, the OPCD, earlier today, challenging the validity of the constitution of this chamber and the single judge. Now, I note, Your Honour, that the filing was dismissed in limine by the pretrial division on the basis that it was filed in the wrong, before the wrong authority, but it has not yet been disposed of the merits, on the merits. Now, if and when it is refiled, the prosecution will respond on the merits. But given that if the submissions of the OPCD turn out to be correct, it may have significant ramifications regarding the validity of these proceedings. Now, in these circumstances, the prosecution deems it to be desirable that this matter be raised in the presence of the suspect and to invite his submissions on this, if any, in particular to invite him to agree that he is happy for this matter to be convened before this chamber rather than to have the matter postponed until the chamber can be reconstituted. The prosecution submits that it is normal for first initial appearances to take place before a single judge, and that as regards the rights of the suspect, it makes a very little difference as to whether that single judge has been appointed by the president of the pretrial chamber, alternatively appointed by the pretrial chamber who is assigned the case. To the contrary, if the matter were to be delayed, this would in turn likely increase the time of the suspect's pretrial detention, which, in light of the view that the prosecution has taken on the issue of detention, would be contrary to his rights and interests. So may I request, Your Honor, that the suspect be asked to confirm that he's happy that the matter proceed, and that he will abide by any decisions of this chamber regardless of the outcome of those proceedings. Before I yield the floor, Your Honor, I would like to mention that I would also like to make certain submissions on the issue of legal representation, and I may briefly touch upon the issue of interim release, but I may, for the forewarning of the court officer, I may ask that the chamber go into private session briefly to make certain submissions and references to confidential filings. Thank you, Your Honor.
Has Mr. Steinberg handed over the floor to me on the first observation? Okay.
Monsieur Gacheru, je vous donne
Gacheru,
la parole, ne vous en faites
I
pas.
will give you the floor. Please don't be concerned about that. I will give you the floor. But I would first like to give a quick response to the representative of the prosecutor to say that, as he explained at the beginning of his statement, the first question he raised relates to the merits of the case, and I think, as you put it so well, we are really at a very, very early stage in this, and the decision appointing the judge of the chamber was an administrative decision, and it runs until there is any decision to the contrary, until new orders. So I will give the floor at the appropriate point. But you said you wanted us to move into private session. To what question does that refer?
Not immediately, Your Honor.
Okay, d'accord, merci.
In a moment.
Merci.
Thank you. So not at this juncture. No, not at this juncture.
Si vous n'avez
So if you have nothing further to say, I would like to ask Mr. Gacheru whether he has any comments to make.
Honorable Judge, I have comments to make.
Oui, je vous entends. Oui, oui, je vous entends.
Yes,
Je vous entends, Monsieur Gacheru.
I can hear you, Mr. Gacheru.
I have comments to make. Honorable Judge, you have touched on the issue of the confirmation of hearing, and also the charges were read out to me. I was not, however, asked, and I wish this to go on record, that I do not intend to admit the charges under Article 65. So I wish to state, for purposes of clarity, that the allegations read out to me are not true. They are false. all of them, the 6 of them are false. And Honorable Judge, that is why I think you have given us a timetable for confirmation, which I'm quite happy with, and which the timetable is in order. On the issue of interim release, Mr. Steinberg has requested that he would want the court to go into a private session, so I will reserve my comments on that. And on the issue of whether the court should continue, the pretrial chamber should continue handling the matter in spite of the objection, I agree with the court. Judge, there is already an order, there is already a ruling by the president of the pretrial chamber assigning this case to this court. That order has not been set aside. So as matters now stand, we are perfectly entitled to proceed before this court. I agree with your observation that this is an administrative issue. And so long as the order is still there, the right forum is this particular chamber. Those are the observations I wish to make at this point. And thank you.
Thank you, Mr. Gacheru. Thank you, Your Honor.
Merci, Monsieur Gacheru. Nous prenons bonne note de...
Thank you, Mr. Gacheru. We take note of your observations.
I apologize for interrupting, Your Honor. If I may then address the next issue on my agenda, and that's just to briefly make some observations regarding legal representation. Obviously, Mr. Gacheru has a right to represent himself, but I note that in his in the registry's recent filing, they indicate that Mr. Gacheru had informed them that he intends to, and I quote, "review my position during any subsequent appearances," unquote. Now, while the prosecution accepts that Mr. Gacheru is a qualified lawyer in his domestic jurisdiction, I think we all in this room appreciate how different the proceedings before this court can be. And in particular, Your Honor, I'm not sure that the suspect, Mr. Gacheru, fully appreciates the enormity and complexity and logistical challenges associated with pretrial proceedings, including the use of IT tools employed by the court, pretrial filings, many of which have already been instructed today, and also the issues of dealing with disclosure. So my request, Your Honor, is that Your Honor may advise the Mr. Gacheru of the desirability of appointing counsel as soon as possible, and particularly, Your Honor, if one is to meet the deadlines already being set by this court, if there's any significant delay in the appointment of counsel, one can imagine the logistical challenges of dealing with disclosure while an accused may be remote in a different country several thousand miles away. So, Your Honors, I would request that the accused be advised that it would be in his interests to appoint counsel, and if he chooses not to, the prosecution may approach the chamber for an order appointing counsel to assist him, regardless of that choice. But that is a matter to be dealt with on another day. Thank you, Your Honor.
Merci, Monsieur le représentant du procureur.
Thank you, representatives of the prosecutor. Monsieur Gacheru, you, I think, have followed the observations of the representative of the prosecution. What would you like to say, do you have any response to these observations?
Judge, I appreciate Mr. Steinberg's concern and I'm grateful to him. The decision, naturally, I have the right to either represent myself or be represented by counsel. I leave all the options open, and Your Ladyship, I appreciate the concern. That is an issue I will take up at the appropriate moment. Thank you.
Monsieur Gacheru, c'est ce que j'ai cru comprendre à travers les échanges que nous avons faits.
From the exchanges we've had, Mr. Gacheru, I believe that the choice of a counsel remains open to you. That's part of the fair and fair trial. And I would say that given the complexity of a case before the International Criminal Court, I would counsel you to choose counsel for yourself, but you do have the right to make this decision yourself. And
Nous approchons petit à petit.
We are slowly coming towards the end of this initial appearance hearing, but I would, before we close, I would like, if there are any observations, Mr. Prosecutor, with regard to the matter of the single judge appointed, and also any observations you might have relating to the representation of the suspect before the ICC, that you put these comments into writing. That will also give Mr. Gacheru the time to confirm or not his latest comments with regard to being heard by the single judge, and also on the question of representation. That will give him time to reflect on the subject and decide at an appropriate date. That is what I wanted to suggest. That will enable us to make some progress in these proceedings, particularly because the suspect did surrender voluntarily. I don't think we want things to drag at this stage.
As the court pleases, Your Honour, I will certainly do so as soon as possible. If I may raise one other issue then before we move on to the question of interim release. I note that the the Chamber has ordered the prosecution to file by the 18th of November a status report on inter alia the progress of in relation to disclosure. But I would like to just bring to the Chamber's attention that before disclosure can be safely effected, there are certain procedural matters that need to be attended to. In particular, Your Honour, I mentioned 3 protocols which the prosecution would request are finalized prior to the initial disclosure taking place. I can in fact inform the Chamber that the prosecution already has its first disclosure package ready to go as soon as the relevant protocols are put in place. These 3 protocols, Your Honour, are firstly the very technical one, the e-court protocol. The prosecution will submit or submits today as the Chamber pleases that the most recent protocol filed in ICC 0205 01/20 116 Annex 1 should be adopted. Then the redactions protocols, Your Honour, will also need to be put in place, as well as the protocol, importantly, on the handling of confidential information during investigations and contact between the party and participants and witnesses of the other party and participants. So I make those observations and leave that in the hands of the court for now. Now, yes, I think it's not necessary to address that at the moment. If I may then just ask that we go briefly into private session so I can make certain observations regarding matters which are currently classified in a manner that doesn't permit me to refer to them in public session.
Oui, nous pouvons le faire, Madame la greffière. Vous pouvez.
Yes, we can do that. Court officer, could you please take care of this?
We are back in open session, Your Honor.
Merci beaucoup, Madame la greffière.
Judge Alapini, thank you very much, Madam Courtroom Officer. Mr. Prosecutor, I'd like to give you the floor as to the matter of severance.
Thank you, Your Honour. The prosecution notes the views of the Chamber on this issue, and the prosecution has no objection to the severance of this matter. Should the other suspect be arrested in the interim, the prosecution will always have the opportunity to request the matters to be joined, subject, of course, to the right of the accused to a speedy trial. Unless the Chamber instructs us, we see no reason to file further written submissions on this issue. But of course, if Your Honour would still prefer us to file anything in writing, we will do so.
Justement, c'est pour cela que
Judge Alapini, that was why I was asking you for your opinion, and filings would be a means of reinforcing the position.
oui. Ainsi que quand je fixais les délais tout à l'heure,
So when I am going to schedule a little bit later, you will see that you'll be able to make observations in your filings on certain matters of law associated with the presence of Mr. Gacheru at the International Criminal Court. You will be able to do that rapidly for us to be able to remain within reasonable time limits. Mr. Gacheru, I would like to give you the floor. Do you have anything further to add to the observations you've already made?
Only one observation regarding the last issue which Counsel Mr. Steinberg has dealt with. I similarly agree, as he does, that we can separate the trials, and this is for the basic reason that we do not know when the other accused person will surrender if he will, and that is my position as at now. And I also agree with the observation by the court that we can file written observations to firm up our positions. Save for that, I think I do not have any other comment.
je vous remercie.
Judge Alapini, I'd like to thank you very much, Mr. Gacheru, and I believe that this brings us to the end of the initial appearance hearing in the case against you. I would like at this juncture to thank all the participants in this hearing, the interpreters, the court reporters, the technicians, and all other individuals without whom this hearing would not have been possible. So thank you once again, and I wish you a lot of courage during this difficult time that we are living through, this health crisis. So, now, the hearing is adjourned.
All rise. Veuillez vous lever.